Bwana kweli.
Umefanyishwa kazi leo. Unajua they say they are going to produce him in you want to be demanding so we have to come this the future of crop and now having new ones. Yeah, he's already here.
Alongside Mr. Kimon, the state.
Please approach your lap. My name is Ndegwa Njiru. Ndegwa Njiru. I appear alongside Mr. John Jomo. Present. Ms. Sarah Chile. And Mr. Mila Mageta. Present. We are here for the practice.
Your Honor, this matter is coming up for me. On a timely basis, the case has been brought before this court with a charge that had been withdrawn. The case was Kiambu NCCR E775 of 2021. And the case was withdrawn because the accused failed or neglected to come to court. The prosecution applied for forfeiture of cash bail.
You know, the procedure, the DPP.
I'm laying a basis.
I'm on my feet.
You'll have your time.
I'm on my feet. The procedure that the DPP is introducing before you this morning is alien to these proceedings. The procedure that I know is that once an accused person is brought before you, Your Honor, he takes plea. There is nothing called like laying the basis, because what the DPP is attempting to do is to dissuade this court and prejudice the mind of this court. Let the DPP do what is done in normal circumstances. This is a normal case provided for under the penal code. Let her have the accused person take plea. There is nothing called laying the basis, and she cannot introduce new procedures.
Before you proceed, Your Honor, let me correct the case number. Okay. The case number. No, that is the previous one. We cannot reflect. Yes.
John Koimburi, you have a first count.
You know, before the accused persons take plea, we have an objection. Once the accused person pleading the charges before you, and And Your Honor, if you may allow me that I'll address you, then my colleagues will equally address you from the objection.
Counsel is contradicting itself. They just told you to sit down and to proceed with the plea.
Yeah.
And that is the procedure.
Because Your Honor,
Yes.
what you want to do is to bring the abuse.
You can bring it after
The abuse that the DPP is perpetrating through this charge sheet and the mischief.
Well, let us take the plea first.
Because,
all
Your
that
Honor,
will come after the plea.
Our objection is on this basis, Your Honor. It's under section 87.
I will say it like this. This is the then I listen to everyone.
Yes.
Your client has a right to refuse.
That's correct, Your Honor. We are not even objecting to him pleading. What we want to bring to the attention of the court is the mischief being perpetrated by the DPP. For one reason, Your Honor, as correctly put by DPP, this court was previously seized of similar matters.
Unless if you want to respond to what you're saying, then I have to allow her to finish talking and then you respond.
You know, unless therefore she's making an application to have this new charge admitted, then I'll respond. But as long as she's making an application for lay basis, Your Honor, it fights itself.
We
no
stopped
place
that, Your Honor.
in the focus in the
He's
criminal
taking us
proceedings.
back. We stopped that. Let us take
Your Honor,
the
may I allow it? May I address you? Then you can make a determination as to whether I am sufficiently addressing your points of law, or we go to the taking of evidence.
Okay, let me let's the plea and then I listen to all these allegations. Before I make any other one.
Maybe just a very small
Say
intervention.
I follow the procedure, let's follow this.
Yes.
Yes.
By taking plea and then I listen to all this.
Yes, Your Honor, as you follow that procedure, the reason why my colleague is raising this issue, the charge sheet has been furnished to us in a copy of the charge sheet. And all the counts, if you look at count number 7, as it takes the plea.
Your Honor, there is nothing before you. Before he takes the plea, you cannot
It's a
proceed to
matter
anything.
that is relevant.
Let us follow the procedure, please.
Because this plea or the charge sheet is introducing a matter that is already before the court. We have been cited a case number E715 of 2021, and that file is not before the court. So that the question that the court should be asking itself, even as we look at the plea, is what the status of this particular matter. We are bringing a new charge sheet with a new charge, a new count on a matter that is already before the court. This file has not been available to the court,
Counsel is
so that we can also
misleading
have
you,
the
my
advantage.
Honor. Counsel is misleading you.
Let
There
me
is
just-
nothing
let-
before this court.
let me
No,
just finish.
I will not allow him to mislead
Let me
you.
just finish.
Because the matter was withdrawn.
Let
and this is
me
fresh.
just finish. This is court record.
Please let us.
This is a court
Let's
record.
go.
This was a charge
Don't
sheet
touch us.
that between 29 July 2021 and 29 August 2022 at Kiambu within Kiambu County, Kiambu Chief Magistrate Criminal Case number 715 of 2021. That is part of the record of the court. Even if that matter, Your Honor, is withdrawn, that is still part of the record. So that, Your Honor, the accused person is required to plead to a charge on a matter that is not before the court. He has no advantage of saying yes or no on a charge, on a file that should be before the court. For him to respond to this, Your Honor, as a plea, he's supposed to say, I plead guilty or not guilty. How can he respond to this particular charge on a file that is not before him?
Let's proceed with
Has he been given that particular
All
file,
right,
Your Honor?
Wakili, that's enough. Thank you. Let's proceed with the plea, and then I'll listen to all this and actually write.
Your Honor, the concern is how
We are
is it to respond
proceeding with the plea.
to this particular charge and count
You-
without the file
You know,
in the court?
this is also something else, and I respect the directions of the court. What happens to a case that has been withdrawn under Section 87A? Is the DPP supposed to bring new fresh charges, or is the old matter revived? That's a question of law, Your Honor. I wish you to determine.
Plea.
You know, is it that we
No,
are
I'll
not
listen to
addressing a
all-
question of law?
No, I want us to follow the procedure. Let's do the plea, and then I'll make all.
But how about the abuse being perpetuated by the DPP? Can the court close its eyes to the abuse being perpetuated by the DPP?
All right, place aside. Consider the matters.
Because that is the question. The abuse being perpetuated by the DPP. We cannot allow it to pass the eyes of the court.
All right, let me do the simple matters, and then I'll come back to you.
Most obliged.
James Mwangi.
James wants respect the court.
James Mwangi. Unashtakiwa na kupatikana na dawa za kulevya ambayo ni kinyume na sheria.
Conference has resolved to indicate to the court that we record the following preliminary objection in light of section 87, paragraph A of the CPC. While looking at that, Your Honor, the specific objection is in respect to the proposed charge of count 7 of the charge sheet. And this is the basis of our objection. I'll address you on part of it, then my colleagues will address you. Your Honor, as correctly captioned by count 7 of the charge sheet, the accused persons before Your Honor was previously charged of the same counts, that is count number 1 up to 6, in criminal case E715 of 2021. Subsequently, Your Honor, the DPP exercised his powers under section 87 plus paragraph A and withdrew that case. He has now again, Your Honor, appeared before you under the same section again, exercising his rights to charge for the same offenses that had previously been charged. And while, Your Honor, we have no objection to our client taking plea in respect to count 1 to count 7 to count 6, our objection is in respect of the mischief being perpetuated and the abuse of power being perpetuated by the DPP by invoking section 121I of the Penal Code. To that, Your Honor, in that respect,
121 of the
section 121, subsection 1I of the Penal Code. And the charge reads, failing to attend court contrary to that section. Where did he fail to attend court? In that case that was withdrawn under section 87A. So our simple application, Your Honor, when a case has been withdrawn under section 87A, is the DPP permitted by the law to introduce new charges in the same file, or is the DPP limited to the charges contained in the initial file? You know, I leave it to Mr. Jomo and Mr. Manzo to proceed, and my colleagues.
Your Honor, the observation that I had made before as regards count number 7 that has been framed by the DPP is on the difficulties that are being advanced prejudicial to the accused person to respond to that particular charge. Because if you look at the particulars of that offense, is that it is referring to a matter 715 of 2021.
Sorry, I forgot your name.
Njomo. So that what is the fate of the accused person in saying, responding yes or no, even keeping quiet, as regards that particular count? That is the inability that faces the accused person at this moment, because he doesn't know the particulars to which that offense relates. The only fair procedure, because the accused person is entitled to a fair procedure and a fair hearing, is that those issues of 715 of 2021 must be dealt with within that particular case, so that, Your Honor, he can come and tell you that the reason why I did not attend court, assuming that the matter was withdrawn because of failure to attend court, was because of 1, 2, 3 reasons, and it happens all the time. We don't know, as we stand here, or he doesn't know, whether there were warrants in place that he can respond to say whether it is true or not true. He does not know whether he had been served with any warrants, if any had been issued, so that he can again say it is true or it is not true. In summary, Your Honor, it is not possible for the accused person at this juncture in time to respond to any allegations in 7/15 of 2021 without having the benefit of the record of that particular file, so that as he can respond to all the other offenses, this particular count number 7 will be a difficult position for him that he cannot respond to. In all fairness, Your Honor, bringing this particular count at this point in time without any information at all would be highly prejudicial and will flout the rules of fair procedure and his constitutional right to a fair hearing. We oppose to that particular count and charge being pleaded to.
Your Honor, with your kind permission, my name is Daniel Manson. Your Honor, a matter reinstated under 87A of the CPC means that it had already been pleaded to and the plea responded to. And in this matter, it was a plea of not guilty. So, Your Honor, in the event that matter is reinstated, then it proceeds from where it was left and from the record of the court as of the time it was withdrawn. So if it's a particular file and it's a particular matter, Your Honor, what needs to be done is to bring the person back to court and then proceed with the hearing of that particular matter. I'm aware the prosecution is allowed to amend charges anytime, but that should that happen, then, Your Honor, there should be a totally new charge. It's a totally different file now if you are to bring up matters. Although you can amend, Your Honor, under the law, it doesn't mean you have to plead again. We have to know what is the status. And for purposes of Article 50, Your Honor, then the accused person has to be accorded an opportunity to explain themselves as to any times he may have missed case or the court case, and also to ascertain whether the days the accused person was not present, whether the matter had already been withdrawn or had been negotiated for withdrawal. We therefore plead with you, Your Honor, that we proceed with the original case, and should there be any need to amend charges or add charges, then there be a proper notification to an accused person so that before they plead, they have already been notified of their charges.
You know, allow me to summarize by referring you again to section 87 and the last part of it. It says, if it is made before the accused person is called upon to make his defense, he shall be discharged. Now that's where we begin, a comma. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on count of the same facts. What is before you does not square out with the requirement of section 87, paragraph A. What is required is that he shall be prosecuted, subsequent proceedings against him on account of the same facts. Does the charge sheet before you, is it a new charge sheet, or does it present the qualifications and the principles and the tenets elucidated by section 87A? Number 2, and the final one. Is this an amended charge sheet? So that then we understand that the DPP has exercised that right. We are most obliged.
Thank you, Your Honor. I wish to submit that the believe that the objection has no basis. The previous case against the accused person, that is file number 715 of 2021, was withdrawn under section 87A. Your Honor, the same section of the CPC gives the DPP power to reinstate the case and does not limit the DPP to conduct further investigation and even bring new charges based on the same facts. I must submit that the charge they are contesting to is a charge that has been brought, which is within the facts that the accused person was charged in count 1 to 6. Nothing in law stops the DPP from amending a charge sheet. And in this case, we are not amending a charge sheet. This is a fresh charge. And that is why the case has been given a new number. It is number E343 of 2024. So once the matter has been withdrawn, the previous number ceases to exist. And we have brought accused person with same charges, and further investigations were done, and additional charge was added. So, Your Honor, it is not prejudicial for the accused person to take plea and answer to the new charge. He will have time to respond. We are going to serve him with the statements of the witnesses. He's well represented by a team of advocates who are even senior than me. I can see Mr. Manzo here, my good friend. They'll represent him and be able to respond to the charges. So I don't see that anything that stops this court from taking plea. It's our submission that the court allows the plea to be taken to enable the accused person answer to the charges. That would be all.
Okay, well, this is what I'll say. Let me give you a ruling date for tomorrow, and then we proceed. I have my opinion, but I want to consolidate my thoughts.
Okay. Yes, Your Honor, we highly appreciate the case of the court. Yesterday, Your Honor, when our client was arrested by the DCI, when we appeared before and we're making an application for bail, we're laying the basis for it. You know, when our client was arrested yesterday, he was presented before the DCI, Serious Crime Unit. The offense that we signed the precautionary court statement to was about cybercrime.
Okay.
I'm laying the basis for my
I don't know
application.
that one, Your Honor. Please handle the case before the court.
Okay, then what I'll say, let me just take a few minutes, I do the ruling, I come and deliver, so that we can move forward together.
Yeah.
That would be fair, Your Honor.
Because I realize now we are going to...
Yeah, that would be fair. Because you would have laid the basis how the DPP is abusing his powers and representing other interests other than the case.
Okay, so my ruling is will basically touch on the fact, the issues you raised.
Yes, specifically,
Not
they specifically count number 7.
On number 7
We are most
also
obliged.
affects the other counts.
We are most obliged.
In 30 minutes,
We are most
I
obliged.
have to give the court to my colleague. So once she's done, we'll back.
We are most obliged, Your Honor.
Judge Koimburi.
So I have a brief ruling. So the accused is charged several offences, including forgery. The accused person is yet to plead. However, preliminary objection has been raised. The accused team of advocates object to plea taking on count 7 of the charge sheet, and also the fact that the charge sheet is prejudicial as the matter was previously withdrawn under Section 87A of the CPC. That there is mischief by the ODPP by invoking Section 121 of the Penal Code. That should the DPP be allowed to bring fresh charges after withdrawal, or should they be brought under the old file number 715 of 2021? That the accused person cannot respond to the new charges as introduced, as the facts are within the old file which have not been interrogated by the accused. That it cannot tell if it is true or not true. Further, the accused already pleaded to the old charges and entered a plea of not guilty. That the ODPP can proceed to amend the charge sheet at any time that they pray to proceed under the original file. That the rights of the accused and Article 50 have been infringed. The ODPP responded that the Section 87A of the CPC gives power to the ODPP to reinstate the case and bring new charges. Hence, a new number will be given. That the accused can take plea and all the relevant documents will be served upon him. Hence, no prejudice will be suffered. That the rights of the accused have not been infringed and nothing stops the accused from taking the plea afresh. So, on analysis, the court is considering whether the file should be, whether the matter should proceed under the new file. And whether count 7 is an abuse of court process. Section 87A of the Criminal Procedure Code, which has been read by Wakili, reiterate that one. In a trial before a subordinate court, the public prosecutor, with the consent of the court or on the instructions of the ODPP, at any time before judgment is pronounced, can withdraw from the prosecution of any person, and upon such withdrawal, A, if it is made before the accused person is called upon to make his defense, he shall be discharged. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on account of the same facts. More importantly, I refer to this case, more importantly, where either of the subsections under Section 87A and B of the case are invoked, an aggrieved party has sufficient avenues of other rights to further his rights under the Bill of Rights. The act of likelihood to reopen the case against an accused person should not be a bar under Section 87A of the CPC. The constitutional provision of Article 50 engraves fair trial until final judgment is pronounced by the court. It's therefore immaterial for the court under Section 87A of the CPC to prohibit withdrawal on grounds of accused suffering any prejudice. If the charges would suffer prejudice if fresh charges are to be filed by the state. That is the case of Republic versus Leonard Senketo 2019. But the court is not seized of the old matters to determine the reasons for withdrawal of the case and at what stage this same was withdrawn. The court, however, under Section 87 of the CPC is aware that the ODPP have power to withdraw and reinstate the suit or bring fresh and similar charges before the court over the same set of facts. The court shall not bar any subsequent proceedings as presented by virtue of that section. The same case proceeded to say the role of the court is clearly defined under Article 51 of the Constitution, solely to decide fairly and independently on cases brought and filed by respective parties, including the state. The jurisdiction of subordinate courts is well defined in the respective statutes and must therefore act within the bounds of that authority. The trial court, on receiving the request under Section 87A and B, has power to judicially consider elements of the provisions and proceed to give effect in the manner stated in the court. That is the same case of Republic versus Leonard Senketo. Bringing fresh charges over the same facts fall within the ambit of Section 87A of the CPC. On the additional charge under Section 121 of the Penal Code that is not known to the accused will have his chance to be served the documents relating to the suit as to enable him. I've already made my ruling. I cannot consider the ones you're bringing now.
No, that does not relate to this.
Okay.
It's another subsequent application.
Oh, okay. So the accused will have his chance to be served with the documents relating to the suit as to enable him defend himself appropriately. This includes the record or information that is deemed to have so failed to attend court. This is the plea stage, and it is only after the charges have been read to the accused that the relevant documents can be supplied to the accused by way of pre-trial to enable him present an appropriate defense as required under Article 50 of the Constitution. If any constitutional breaches are foreseen, then the same can be raised at the appropriate forum. The court finds no prejudice will be suffered as the accused will have ample time to prepare and defend himself. That is to say, the criminal objection is dismissed, have a right to appeal.
You appreciate the ruling of the court and ask the court to grant us the type of proceedings and the ruling. We would wish to launch an appeal on the count of the court's decision. We shall however proceed to undertake the business of today.
Okay.
We shall raise the next objection as and when we get there.
Okay.
We are most obliged, Your Honor.
I believe everybody is there. I just want to write quorum as before.
Yes.
Yes,
No.
You know, we have added someone, our colleague,
Added
Mr.
someone.
Auditor, who is now with us.
Okay. Quorum as before, and then I add one more name. You said your name is? Still for the accused, eh?
Yes,
Okay.
Maybe for purposes of order, then it can go on record that we are being led by Mr. Manzo, our senior, for order purposes.
So I believe we proceed to plea.
Yes.
Judge Koimburi, you are being charged with forgery contrary to section 345 as read with section 349 of the Penal Code. The particulars being that between the months of November and December 1994, at an unknown time and place within the Republic of Kenya, with the intent to receive forged the Kenya National Examination Council certificate, to wit, a Kenya Certificate of Secondary Education Certificate, serial number 2015684, purporting it to be a genuine and duly signed certificate issued by the Kenya National Examination Council. True or not true? You have a second count, that is forgery contrary to section 345 as read with section 349 of the Penal Code. The particulars being that between September 2011 and April 2012, at an unknown time and place within the Republic of Kenya, with the intent to receive forged a Jomo Kenyatta University of Agriculture and Technology certificate of participation in the East Africa Universities Accession Project, serial number JKU/Kenneth/E1/2011 to 2012/C6, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have that count, that is forgery contrary to section 345 as read with section 349 of the Penal Code. The particulars being that between September 2011 and April 2012, at an unknown time and place within the Republic of Kenya, with the intent to receive forged Jomo Kenyatta University of Agriculture and Technology Academic Excellence certificate from the Department of School of Human Resource Development, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a fourth count, that is uttering a false document contrary to section 353 of the Penal Code. The particulars being that on the 8th of March 2021, at the Ethics and Anti-Corruption Commission, knowingly and fraudulently uttered a forged Kenya National Examination Council certificate, to wit, a Kenya Certificate of Secondary Education Certificate, serial number 2015684, purporting it to be a genuine and duly signed certificate issued by the Kenya National Examination Council. True or not true? You have a fifth count, that is uttering a false document contrary to section 353 of the Penal Code. The particulars being that on the 8th day of March 2021, at the Ethics and Anti-Corruption Commission, knowingly and fraudulently uttered a forged Jomo Kenyatta University of Agriculture and Technology certificate of participation in the East African Universities Accession Project, serial number JKU/Kenneth/E1/2011 to 2012/C6, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a sixth count, that is uttering a false document contrary to section 353 of the Penal Code. The particulars of the offense being that on the 8th of March 2021, at the Ethics and Anti-Corruption Commission, officers knowingly and fraudulently uttered a forged Jomo Kenyatta University of Agriculture and Technology academic excellence certificate from the Department of School of Human Resource Development, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a second count that is failing.
You know, that's where we are. Before the accused persons pleads to count number 7. We would wish the court to make a determination, and it's a legal question, whether that count discloses an offense. The accused person is charged with the offense of failing to attend court, contrary to section 121, subsection 1, paragraph I. The reading of that section in the penal code, it's our humble submission that the same does not disclose an offense that can warrant the accused person to plead to. Your Honor, our application is backed by Article 50, Clause 2, Paragraph N of the Constitution, and that's where we'll begin. And I'll make brief submissions, and then I'll invite my learned friends to proceed. Your Honor, that section says that every accused person has a right to a fair trial, which includes the right not to be convicted for an offense, for an act or omission that at the time it was committed or omitted was not an offense in Kenya. You know, the basis of that provision is a notorious Latin maxim that nurem crimen sine lege. No one shall be charged on offense if the offense at the time of its alleged occurrence was not an offense in Kenya. I am trying to look for the penal code, Your Honor. And since I don't seem to be getting one from the grave book, allow me to fish it out from my phone. Your Honor, got it. Yeah. You know, section 221 provides these are offenses relating to judicial proceedings. A person who commits any other act of intentional disrespect to any judicial proceedings or to any person before whom such proceedings is being heard spelling is H-A-D. I think Parliament was looking at H-E-A-R-D, and we cannot legislate, or taken is guilty of an offense and is liable to imprisonment for 3 years. The ingredients of this offense, Your Honor, is intentional disrespect to any judicial proceedings or to any person, that is yourself or the previous magistrate, who such proceedings is being heard. The judge is failing to attend. The judge does not square out with the law. And that is a prejudice our client will suffer if he is allowed to plead to an offense that is alien in law. And of course, you may not doubt the mischief by the DPP. It's so that this can form the basis upon which our client will be denied bail. Of course, they will say there are compelling reasons to deny our client bail on the basis of previous absconding. And therefore this application itself is also anticipating the ability of our client to enjoy the rights under Article 49.
Your Honor,
And-
I do object. Counsel has entered into the render of bail. We have not.
I am not there.
Yes, you are there. And even purports to amend the law by correcting what is printed on the law. Let him address the section he's contesting.
I believe the objection lacks basis. That is why the court has not pronounced itself. Your Honor, the law provides for the ingredients. What are the ingredients in this application, this count? It is that on the 29th, between 29th July 2021 and 29th August 2022 at Kiambu, within Kiambu County, being an accused person in Kiambu Chief Magistrate's Court, is number this, failed to attend court on numerous dates that the matter had been fixed for hearing and mentions without any lawful excuse. Our submissions, Your Honor, is that this count does not disclose any offense that is known in our law. Your Honor, we rely on the case of, and I've given it to you, the Court of Appeal case, sorry, the High Court, that is criminal case number E013 2022 MMM versus the Republic. At paragraph 10, Your Honor, the court relies in the case of Sigilani versus R, and this is what the court says. The principle of law governing charge sheet is that an accused person should be charged with an offense known in law. The offense should be disclosed and stated in a clear and unambiguous manner, so that the accused may be able to plead to specific charges that he can understand. It also enables the accused person to prepare for his defense. In the same judgment, Your Honor, you look at the case of the court relied in the Supreme Court of India, the case of that is at paragraph 12, and the court is saying, relying on the Supreme Court of India, that fundamentally a fair and impartial trial has a sacrosanct purpose. It has demonstrable objects that the accused person not be prejudiced. A fair trial is required to be conducted in such a manner which would totally austerize injustice, prejudice, dishonesty, and favorism. Decidedly, there has to be a fair trial and no miscarriage of justice. You know, we invite you to look at that judgment when making your determination. Equally, you look at the judgment in the case of Wilson Minor, Wanjoy, the court of, which is a criminal appeal. Again, the same principle is coming out. That can an accused person plead to an offense that is not in law? Can the DPP manufacture facts and create law? When Article 96 provides that the only person who has the capacity to enact any law is Parliament. In that respect, Your Honor, I invite my learned friends who would wish to object to the accused person pleading to an offense that is not known in law. The section does not provide the question of failure to attend. It provides for disrespect of judicial proceedings and judicial officers. Permit me, as I pen off, to submit that this is an abuse of the court process meant to bring before the court compelling reasons that may require the court to deny our client bail. And that is why mischievously the DPP frames the charge as failure to attend. And I bet my last dollar, Your Honor, in the event the court dismisses my objection, that when the DPP comes to address you on the question of bail, that will be a ground.
Definitely.
I can sit and I bet my last dollar. To that effect, my Lord, Your Honor, permit me to invite Mr. Jomo to proceed.
Just one observation, Your Honor. I know Mr. Aruta has a very to his side. That if you look at this particular, and this is what we had said in the morning, which is relevant. If you look at the offense that has been framed, the scenario that arises or that presents itself, the scenario that presents itself is this. If someone does not appear in court before you, if you give us a date tomorrow, that person is given an opportunity to explain why he did not attend court before a decision is made as to whether bail can be cancelled or whether the matter should proceed when the accused person is in custody. But now what we have here is a situation where a conclusion has been made. This court risks making a decision that is very prejudicial to him without giving him an opportunity to explain if indeed he failed to appear in court in 7/15 of 2021. That opportunity is totally denied the accused person. So that even as the court proceeds to the next stage, after a plea has been taken as to whether the accused person should be admitted to bail, there is a charge that is prejudicial to him that says he has failed to attend court, which then presents a situation of a compelling reason why bail should be denied. You know, that is the point that we are saying that this particular offense, where it's not even provided for in the law, is prejudicial to the interests and rights of the accused person to a fair trial. Mr. Aruta has a point to issue and to make on that particular issue.
I fully concur with the submissions made by Justice Govt, by learned friends. I would just like to give the role of this court in the context of what is before us on the role of the court in administration of justice. And that the court should not entertain those proceedings which clearly point to abuse of court process. It has been confirmed, and I make reference to count 7, that count number 1 all the way to count number 6 is a copy and paste of charges in a previous case, that is E7/15 of 2021, which we need to understand was withdrawn under section 87A. And section 87A.
Your Honor, I do agree that counsel should only submit on count 7 that they raised an preliminary objection, not from count 1 to 6, please. Let us take to count 7.
It should have been keen enough to have noticed that I'm referring to count number 7.
So don't go into the counts that have already delivered.
Very well. We've gone with that. I'm at count number 7. Count number 7 arises facts that allegedly arose in a previous proceeding. It is in the particulars of the offense. And Your Honor, if at all those proceedings were withdrawn under section 87A, hence this, if you look at the charge sheet, the particulars are that in that other case, you failed to attend court. He failed to attend court. That's what it says. Yet, for an offense or for a case to be withdrawn under section 87A, it is the DPP who makes a decision to withdraw, then comes and seeks the sanction of the court. So that then, without us having sight of those proceedings at this stage, he cannot plead to such account of failing to attend previous proceedings. Is it an offense under section 121, subsection 1, paragraph I? Even if he had not attended, it is not an offense under this section. It remains an offense, and then the proceedings that are taken out of that count or that charge are therefore unconstitutional proceedings. So, Your Honor, on the face value, on the count, on the charge that is before you, it should reasonably demonstrate an offense known under the law. Does it do so? It doesn't. So do not subject the person who is before you to the trouble of pleading to a charge that clearly everybody can see is not an offense. The DPP has several remedies for this kind of objections are raised. They can go and plead into their housekeeping issues, but this is not a charge that the accused person should be made to
Yes, Your Honor. I'm not going to repeat.
Let's see the finish and then
All right. Yes, unless any of the advocates has an issue.
No, it's okay.
Yes. Your Honor, with your kind permission, I would like you to look at the Fair Administrative Action Act, number 4 of 2015. And I was privileged to be part of this act, which emanates from different articles of the Constitution, and in section 6 thereof, and in relation to this particular case, whereby it's referring to an existing court file. And Your Honor, unless that file is placed before you, then you would have the benefit of under section 6, whereby the accused person, that law requires you be given an opportunity. And if a judgment has been passed, also given an opportunity to appeal on it or explain themselves. That, Your Honor, has not happened. And therefore, this particular charge has facts which are administrative by the court and also by the DPP. The DPP, in their actions, as much as they are very independent, their actions must also be fair under the Constitution. And therefore, without the perusal of this particular file, it will not be fair to charge the accused person with this particular offense, which we submit does not exist in law as it is framed. Thank you, Your Honor.
Your Honor, if I may, Your Honor, under Article 157, the DPP has powers, and is not required to consult, seek any consent or authority of anyone to prefer any charges or institute prosecutions. Further, Your Honor, the charge under count 7 is a charge that is known in law, And if I can read section 121, 1I, any person who commits any other act of intentional disrespect to any judicial proceedings or to any person before whom such proceeding is being heard or taken. Failure to attend court, willful failure to attend court is disrespect. A mention or a hearing is an order of the court. Your Honor, if a court were to give a mention date or a hearing date in a criminal case where accused person is required to attend unless otherwise explained, that is disregard of the court order. And that is the disrespect that section is talking to. That section of law is complete because it has a penalty section and it is under the penal code, not repealed. It exists. The Fair Administration Action Act, section 6, that Council has alluded to, is a subordinate act to the penal code. Yeah. The penal code is superior in terms of ranking. That's what I mean.
Okay.
Yes. And therefore, for Council to refer to it, Your Honor, it's an administrative action that do not apply to the DPP, and therefore we do not need to adhere to that section. The authorities that has been discussed by learned counsel are based on sound principles of laws. However, they do not apply to this case in question. The counsel, the defense counsel are against this particular section because we have filed our affidavit for opposition of bail, and they have seen where we are coming from and trying to preempt what the state is going to state when we are opposing bail. Your Honor, you have made your ruling that the plea be taken. I still submit that let the accused person take plea, and those other issues, because it touches on the evidence, I do not want to open it because it will be a Pandora box discussing evidence before even we supply. So allow the accused person to take plea. We have filed the affidavit for opposition of bail. We can converse the same. Most of them.
You know, in the brief response, and of course I'll invite my learned friends to make submissions, what is of most importance for the court to determine is whether the ingredients of an offense are disclosed in this count. Is there mens rea? And what is the actus reus? When the accused person is answering to these charges, is he answering to a charge of failure to attend court or disrespect, intentional disrespect of judicial proceedings or judicial officer? What is the actus reus in this count? The other question, Your Honor, is if the law does not support the actus reus, is there an offense that is capable of being pleaded to? I do not want to go to the actual actions of the mens rea, but the actus reus contemplated in this provision is that of intentional disrespect. We submit. Of judicial proceedings and judicial officers. It is far-fetched and a wild imagination, almost similar to what the Supreme Court described as hot air, for the DPP to submit that failure to attend court amounts to disrespect. There cannot be that nexus. For whatever purpose and whatever stretch of imagination the DPP must want. The offense being charged is failure to attend. That is the action. So, Your Honor, we submit that the DPP cannot create a law and purport to charge the accused persons with it. The power of the DPP to charge and the overriding power under Article 157 does not mean that he has the leeway to abuse the process. Any public prosecution under Section 5 of the ODPP Act must meet the objects of Section 5 of the ODPP Act. It must be in public interest. In the fullness of time, Your Honor, when the court sits to determine our objection, it must confine itself to the legal functions of the ODPP, that the charge or the decision to charge must be informed by a law providing for that particular charge. Therefore, if the law does not provide for that charge, irrespective of the DPP's desire to charge, ability to charge, capacity to charge, aggressiveness to charge, there cannot arise a charge of this nature. It's our humble submissions that there is glaring lack of the fundamental principle of actus reus in this charge. And as indicated by the ODPP, Your Honor, she has brought it to your attention that there is an application. We have not seen that application ourselves. It has not been served upon us. But you can see it is premised on that.
I have served.
I'm on my feet. If you want to address the court, you can rise up and address.
Just look at yourself, served the application.
Yeah. Do you want to address the court?
I have nothing to say.
Okay.
We've been maintaining the forum since morning. I'm very impressed. Please don't make me get disappointed. I believe both of us here
Thank you for cautioning her.
Let's impress the government. We've been doing since morning.
Thank you for cautioning her. So, Your Honor, our submissions is that when the people of the Republic of Kenya enacted this constitution, the powers granted by the ODPP under Article 157 were powers that must be exercised within the law. And that the ODPP cannot take the sacrosanct responsibility and role of Parliament and create an offense that does not exist. That is a preserve of Parliament. If Parliament wanted to create a law for failure to attend, there is nothing that would have been so clear for Parliament to create such an offense. It will be prejudicial for our client to plead to an offense that does not exist, because the consequence of taking that plea, Your Honor, will be that the DPP will raise that plea as a compelling reason that will require or necessitate the court to deny our client bail. And that is the entire mischief the ODPP intends to serve with that particular count. You know, I invite Mr. Manza to sum up.
Your Honor, will be very brief. Your Honor, there was an assertion that the Fair Administrative Act number 4 of 2015 is an inferior law to the Penal Code. Your Honor, this falls under Article 47 of the Constitution, which falls under Chapter 4 of the Constitution, which is the Bill of Rights. And therefore, 47 goes on to say Parliament will make a law to make sure that there is fair administration of justice in the country, and therefore that law was passed by Parliament in 2015. Your Honor, if you will be kind enough to look at that Article 47 when you retreat, and also the Fair Administrative Act in its entirety, you'll realize that, Your Honor, under this particular proceedings, and it is clearly indicated that there was a file. This precipitates that then that file has to be brought to you, or a judicial officer has to give evidence, or a judicial officer has to state or complain that they were disrespected. And without that complaint, Your Honor, this charge fails. I submit.
Again, I have to go back and make those together. Very well. Yes. When you come back for bail application,
You know, we didn't get what you're seeking us to concur on.
By the way, your colleague is saying plea on count 7 must be taken. You didn't tell me exactly what you want me to do under this section.
We basically want you to make a finding that a plea cannot be taken if on this particular charge, on the basis that the same falls within the category of the Nurem crimen sine lege.
Your Honor, with your kind permission, if I just may not necessarily go on record, this is uncharted territory. In fact, this particular issue has not been raised in the country, or this particular charge, even after the new constitution. I've been a practicing advocate for 25 years. The DPP's office has not utilized this before. So it is a matter, Your Honor, which I cancel this particular charge, the way it is framed, the disrespect. It's only meant for this particular purpose.
They bring too much. Sometimes they tell them what
It's only meant to achieve the object, of Mr. Koimburi.
Just because my learned colleague from the DPP side mentioned to opposition to bail, I think she mentioned that we have seen something about, just requested for a copy of what she's talking about. And before we retire, there's just one pertinent issue that I would like to highlight in this document.
No, I don't think
it's a judicial document.
She mentioned
It's on record.
She mentioned the document. Is it filed?
It's on record.
It is
Your
fine.
Honor, we've not even reached the bail stage.
It's on record.
And we are not
Your Honor,
we
I
are not
heard the
done
words.
with the plea-taking.
I heard the words that we are preempting what we have seen in the opposition to bail, and that's the remark I want to make. Your Honor, you're being set up as an appellate court to your colleague, and this affidavit, when you retire, just look keenly at paragraphs 2A all the way to paragraph 2H. I saw it being passed.
Pass
It
it to
was
the
returned.
court.
What?
The application.
The application. Just go ahead.
We have served, don't worry about
We have
it.
served.
Yes, we have served to the court and we've served to the defense.
Yes.
Very well.
The court does not have a record.
Let the top
It's
court
in
and
your
the
legal system.
Your Honor, this way it becomes sweeter. He's being charged, or he's proposed to be charged, with failing to attend court on 29 July 2021. We have the proceedings, we have the affidavit, and the affidavit says Inspector Ian Makumi. That
Your
on
Honor, I
29
think counsel is saying
Just allow me.
it is far-fetched.
Just allow me.
Your Honor.
Just allow me to make my subdivisions. Just allow me. You know what I want to say.
I don't
On
know.
29 July 2021, the date in the charge sheet, the accused person was absent, but warrants were not issued since he was seen online, and then logged out. A mention date was fixed for 16th September. Then there were subsequent court attendances. Then, at paragraph F, on 22nd November 2021,
Your Honor, did
the
I lose
accused
to
person-
paragraph F?
Just
I
allow
think this
me.
is now too much, Your Honor.
Just allow me.
This is too much, Your Honor.
Just allow me to make my
No, let
submissions.
the court rule. No. Will not allow. Let the court rule now.
Allow me to make my submissions.
No, it is coming next. So now, we are venturing into the issue of the
Yes.
bail application.
Not at all, Your Honor. I'm just talking about this 29th July 2021 to demonstrate that you're being made an appellate court. So on 22nd November 2021, that issue was dealt with. And the court says, the affidavit says, the accused person was virtually present with his advocate. He explained to court that the last time they were in court, they had network issues. Later, they informed, just allow me to read. Your own affidavit. They were informed to attend court on 8 November 2021,
I don't know whether I should write or not.
but were not able. I'm just reading
Our
the
learned
context.
colleagues on the other side really want to, to interfere with the order of the court. Proceedings are usually in an orderly manner, where a party is given a chance and the other party is given a chance to respond. I think it's important that we know where we are at any given time in the proceedings. If our learned colleagues for the defense wish to us to move to canvassing bone of base, then we proceed with plea taking in count number 7, so that we know where we are. And I think also.
Do you want us to proceed with, put a ruling on everything, bail bond everything, or rather I didn't?
The way I understand it, we canvassed.
Just a minute.
Yeah.
Prefer that I deal with the issue of count 7 as you have asked.
Yeah.
Yes.
And then now I come back and whichever ruling direction it takes, then now we decide if we're going that way.
Just for clarity.
Manzo, Senator, your team.
Yes, Your Honor.
Yes.
Now that that particular document has been mentioned and it is in your file,
It is not.
then they should give you a copy. It
don't
means
mind.
you can look at it. They should give you, it's only fair that they give you a copy.
The point is they haven't argued. They
They have
haven't
not-
argued it. Then they just discussing on.
I think the fairest thing is, Your Honor, you make a determination. Have we now known what happened in court that day?
Your Honor, and I was just assisting the court because we argued our objection. Just allow me to speak. We argued our objection. They responded. We were given a right of rejoinder. My learned friend submitted. I just came to continue. And in the submission by my learned friend, she said, we are preempting what would happen after we have seen the application to object bail. And I'm just saying that the court on 22nd November 2021 dealt with the attendance that is in the charge sheet and said the warrants of arrest were lifted as the matter was fixed for hearing on 14th of March,
Your Honor, we could have timelines because they are taking
the
too
court
much time.
directed that the accused
We
person
could have
to attend
timelines on how to submit.
physically. So why are you charging
We
a
should have
person
timelines on how
with
to
something
submit.
that the court dealt with?
What time, how much time we take to submit? Because
No.
this is going to be endless.
I think, Your Honor, what counsel is trying to direct you is that even the facts as contained in that application is that our client attended court.
And
That's why it's
That is evidence.
Okay,
You're
no,
not
that
touching
is
on
in
the
your
evidence.
affidavit.
It doesn't matter. That is evidence. You're not touching on evidence. Your Honor, I pray that you gave a ruling on that and then we can proceed.
Yeah, but Your Honor, you cannot
To
close.
bail application.
You cannot close your eyes to a pleading that is before you. Counsel was addressed to you on paragraph
2.
Paragraph 2.
Your Honor, maybe just I would not want to interject so much, but I think our colleagues on the other side became very uncomfortable when we served this affidavit.
Yes.
And that is why they are jumping here and there, not knowing where the stage we are in. The issue, this affidavit has not yet been open for canvassing. Because we are still at the plea stage. So I think they should just hold their horses so that we maintain the sanctity of these proceedings.
Retire to do your ruling, but look at paragraph.
Have courteous to the counsel is addressing court.
We have not even made our application.
Yes.
And so I think that these proceedings started becoming disorderly the moment we served this application. And I think that our learned colleagues have been using very weighty terms against the Office of the Director of Public Prosecutions, and at times we just listen. Can it really be said that the Office of the Director of Public Prosecutions is abusing its power in a case which has been pending in court for the last 3 to 4 years? The use of the word mischief. Mischief, that is a term that we in our let us have proceedings which also respect the officers that we are serving.
You know, I understand Honorable Gishohi, who made these orders, is a CM.
It is not right.
I want us to cool down.
Yes. Thank you.
I want us to cool down, and I think sometimes time enables us to cool down. I think that's where communication. I'll give this ruling tomorrow, so we're all in one space. Yes, I'll give this ruling tomorrow. So I think the only issue in here is if there's any objection to him going home on bail. I know you still have that application ready. What? I don't know, we are so full today, actually wanted to know. I mean, it's the Antalya what is the issue? What is the flight risk aspect involved? And as much as I haven't gotten into this, so that I can know in one space rather than allegations. I want to be more objective.
You had your kind permission on that particular issue. Yesterday, the High Court released him on bail.
No, that's a different file. No.
Hold on. And that means the High Court was satisfied that the accused person who is a member of parliament is not a flight case. And I'm very sure if you order him, you will release him on reasonable terms of bail and order him to appear tomorrow in court, I'm sure. You will avail him. He cannot abscond from bail. Cannot even run away from parliamentary proceedings. If he's busy for 8 good days, he will lose his seat in parliament. And when you weigh that together, it's not a flight case, and it is also good we give the court humble time to get a reasoned judgment and probably peruse the court file in this matter so that the court can be well informed before making its decision.
Yes, Your Honor, just a very if you look at the order issued by the High Court yesterday, which is an application that we participated in, is not specific to this particular matter. The context under which that application and why the judge was convinced to issue the orders is because there was an arrest. The accused person had not been charged today. Yesterday there was an arrest, and today he has been brought to court. So that yesterday the judge was convinced that there is a good reason for him to be released on bail. We presented ourselves to the police station, and that order was not complied with. So the only last resort, Your Honor, is that the accused person is now in your hands. he is now the custody of the court. He is not he is now the property of the court. He's not in custody with the police station. He's before you, and there's an order of this court, of the High Court, saying that he should be released upon deposit of 200,000 shillings. What we can confirm before Your Honor is that that cash bill is available. We are willing to comply. If he's directed to appear before this court tomorrow, he'll be here before the court starts sessions, so that there is full compliance. He's a member of parliament. If the court was to give any conditions for his compliance, that will be complied with, so that he appears before you as and when you direct. That order is not specific to this particular case. It is a general order for his compliance and release on bail. That is very much simple, and it has not tied his bail terms to the matter that is before you. It is very general, that is protecting him entirely on all the facts.
In addition, Your Honor, I have not spoken.
I have not spoken either.
You will be granted an opportunity.
I have not commented.
Your Honor, the accused person has pleaded to the 6 counts. And he has raised a legal objection to the legal propriety of count 7. Therefore, until the question of the legal propriety of count 7 is canvassed and the court makes a determination, it cannot form the basis of a compelling reason. Because the court, at the fullness of time, may or may not agree with the defense. In the event it agrees with the defense, then it will fail to become a compelling reason. In the event it agrees with the prosecution, then the court will give the conditions and will evaluate whether it is itself a compelling reason. The balance tilts in favor of the accused having taken plea on 6 counts. It is not fair to the accused person to hold him and deny him bail on mere suspicion and anticipation that he failed. That is, as it is now, with the objections on record, is mere speculation, and it will become a fact when the court delivers itself. To that effect, Your Honor, considering that the application dated the 19th of February is primarily premised on count 7, did you get your copy, Your Honor?
Yes, yes.
Yes, yeah. Considering that the affidavit is primarily premised on count 7, there is no compelling reason. And we are not
I
saying...
really don't want you to venture into this.
Yes.
Because you're taking up another box for her to give you an entire history of God.
And we shall give a rebuttal.
So what I want to know, okay, I want to make it simple because I want to give a timeline until tomorrow.
Yes, Your Honor.
So if you can just focus between today and tomorrow.
Yes, Your Honor.
Not the entire application and what she might raise with you.
Yes, Your Honor. So the balance tilts in our favor. Admit to bail.
You can step in.
I'll let Mr. Kelwan just submit and then I'll finalize.
So the issue I want us to converse is just between today and tomorrow.
Yes.
When I raise it. I don't want to.
No, we are not going to do what they are doing.
Your Honor, from where I sit, I really appreciate that the accused person is a sitting member of parliament, honorable member. Even though all of us are equal before the eyes of the law, we cannot close our eyes to the proceedings that transpired in Kiambu Chief Magistrate.
Again, Your Honor, you have said we limit ourselves.
Today and tomorrow.
Yes.
I want us to focus on
Yeah. He's venturing into issues that we have no ability to respond to.
that short. you objective?
Yes,
Let him proceed.
Let him,
Yes.
I will manage him. myself.
Yeah.
I will not write if I feel it's going beyond what.
We are most obliged.
Thank you for protecting me, Your Honor. What I'm just trying to say, Your Honor, is a decision that will be made by the Honorable Court, which we will respect, really will have to have a basis on what we have filed.
No, you're not again, we object.
Because basically,
Kelon, maybe we can put it this way.
yes,
You started by saying that he is an MP.
yes,
So I want you to tell me whether you think he will have scored between today and tomorrow. And then now I proceed from there. Without me looking, I can't look at everything at the same time.
what
And on
we
the basis of the
procedurally,
High Court.
according to the law and procedure in the Criminal Procedure Code, issues of release on bond or bail or denial thereof are canvassed after plea has been taken.
No.
Unless otherwise. But in this particular case, I would ask on the side of prosecution, we are ready to await the ruling of the court on count number 7, even if it is delivered today or in an hour's time, and then we proceed to the issue of bail thereafter. That will be the procedure.
Your Honor, may I seek your guidance before I start submitting?
Yes.
They have served you with a document that have not been served with, and they have already submitted on it. That one's good. Yeah, that one. I do not know. It's strange to me.
We have a copy for her.
Yeah, so, Counsel, can you just let me submit, please? Or you tell other counsel to address me like you. So,
Wakili, that's why I'm saying we need to cool off.
Yes.
There's really, it's not a matter of.
I'm usually a very cool lady until this guy sorry, this counsel provokes me.
Well, I think I've told you enough. Just retire and.
No.
Yeah.
Maybe it's my time, counsel.
I believe tomorrow will actually be in a better mood. That's why I'm saying it.
I offer to buy her some lunch.
Yeah, you need
No, seniority doesn't allow that. You have to seek leave.
Mr. Manzo had already promised to buy me lunch. He's the senior most. I'll take you at another time. So, back to business, Your Honor. May I comment on this document, this order that was given? This relates to a different case that I do not know. I've not seen this file. And I will not belabor much on whether it was granted bond or not by the court. Plea taking is not complete. The process of plea taking is not complete. So by releasing the accused person on a temporary bond, if I may call it, it may not be procedural. Our request is he goes back to Kampunji and comes tomorrow. We canvass bail. We wait for your ruling, and we then canvass bail. He has a right to bail, which is not absolute. We shall respond. That is my submission.
Briefly, Jada Yora, only on a small single unit of law. There is nothing in law that is said plea is not complete. The accused person has taken plea on 6 counts. An objection has been raised, a legal objection has been raised as the legal propriety of count 7. Additionally, Your Honor, under Article 49, Clause 1, Paragraph H, provides an arrested person has a right to be released on bail or bond on reasonable conditions pending a charge or a trial. We already entered into the depth of the trial. We have jumped from the deeper end unless there are compelling reasons. As at now, there is no compelling reason. A charge has been read, plea taken on 6 counts. So, Your Honor, we also cleave. We crave on H to admit the accused person on bail. You have sought them to address you on whether being a member of parliament is a flight risk. They have not addressed you on that particular issue. We submit, Your Honor, that again the balance tilts in favor of the accused person. I can see his fellow members of parliament here, Honorable Jane Kihara from Naivasha, and Honorable Henya Dirango. No, Mwafrika, sorry. I'm sorry, I beg your pardon.
Surely, Your Honor, is actually necessary.
They can stand surety for them and make sure that he is brought. In any case, he is a state officer. He still has a right to represent his constituents. He has not done it for 2 days now, yesterday and today. Are really there compelling reasons to deny him bail, Your Honor? The DPP has not provided it. And count 7 cannot be the basis because it has not been pleaded. I'm also obliged.
Not to mention that we also his constituents. Including the DPP.
Yes, I am.
Yes, she is.
Equally representing her.
Yes.
So your representation is here.
Yes, we are together.
Now my head is there.
You know, she's still accusing me of making your head go round.
Initially, I said I wanted us to just enjoy the matters tomorrow, but then now things are just. I just have to follow my objectives on this one. And still give a ruling date for tomorrow. Mheshimiwa, usipokuja hapa kesho, mimi hata hii file sita allocate mtu mwingine, tutapigana na wewe mpaka mwisho.
Mashallah.
I will not even allocate the file because I'll be losing my own integrity in front even of the DPP because atasema wewe ndio wao wame-submit na wewe haujakuja. I'll still put the ruling for tomorrow so that I'm more sober and I go and research on some of these things you placed. I really never heard of them. I always see DPP doing absconding. Hii kama tumezoea hii, sio? So I'll give you a date of ruling for tomorrow. I think on the basis of the High Court order, which Madam Omunga says she has not seen, I'll still rely on that one, and then I'll make my ruling on bail or bond tomorrow, so that we are more in one place. In the meantime, Ndegwa and Onunga, tafadhalini, vita ziishie hapa leo. Let's represent our people fairly, objectively, everything. So. So on the basis of the High Court order, in High Court Miscellaneous 28 of 2025, the accused shall be released on the same bond terms until tomorrow, when the court will deal further with the issue of bail or bond, being as it were that is a state officer, and the court believes that he will attend court for ruling in further orders tomorrow.
And kindly allow me to convey my apology to Honorable Mwafrika that I referred to him by the wrong names.
Time indication, you can come at 10.
10, yeah.
That's okay.
Because I usually have to handle other matters first.
We apologize for
Tomorrow I'm sure you'll all be in one space.
So let's put on until tomorrow.
You're most surprised.
Thank you.
Mheshimiwa, unajua napeleka kama leo nini utafanya atoroke? Sasa hapo tumewagonga. Aje tuingie hapa. Thank you.
One problem after another. God is there.